Good day, everyone. I am Donna May and Peanut, and I was tasked to report about Batas Pambansa Bilang 22 or the Anti-Bouncing Check Law. So the long title of this law is it is an act penalizing the making or drawing and issuance of a check without sufficient funds or credit and for other purposes. So it was effective on April 24, 1979. It was also drafted by Honorable Estelito Mendoza as Cabinet Bill number 9. Just a fun fact, Honorable Estelito Mendoza was then the Solicitor General of the Philippines, and he was also a member of the interim Batasang Pambansa. So this law was actually enacted at a time when the stability and commercial value of the checks, which are recognized as being virtual substitutes for currency, were being threatened by the rampant issuance of checks that were subsequently dishonored by drawy banks. Checks are intended and are expected to serve as payment. The payee expects to realize cash when he presents the check to the bank. Thus, the purpose of this law is to enhance the reliability which checks should enjoy as medium of payment and to prevent the injury to trade, commerce, and banking which the circulation of a worthless check inflicts. With this, it is really the main intention of the law to make the issuer of a worthless check liable, since the introduction of worthless checks is not just harmful to the innocent payees, but the entire economy as well. So what are bouncing checks? Bouncing checks are actually checks which were returned by the bank because their issuers do not have sufficient funds on deposit. So who are the parties in a check issuance? We have three here. So the first one is the drawer or maker, who owns an account in the bank or the person who executes the check. Second is the payee or the holder, the person to whom the check is drawn payable. Third is the drawee bank or the one commanded by the drawer to pay the payee. So we have here an example of a check. So in here, our drawer or maker of the check is Mr. Luchito H. Pinat. And the payee is Febeco, while the drawee bank is East West Bank. So that's just a simple example of a check. Now we have two laws that criminalizes and punishes the issuance of bouncing check. The first one is Article 315, paragraph 2D of the Revised Penal Code, which results to estafa. So this law was an older law. So it was approved around December 1930. So the essential elements for a crime to result to estafa is the first one is that a check is post-dated or issued in payment of an obligation contracted at the time the check is issued. Second element is that there must be lack or insufficiency of funds to cover the check. And lastly, the damage to the payee thereof. So the second law that we have is this one, the one that we're talking about. The Batas Pambansa Bilang 22 or the Anti-Bouncing Check Law. So for its essential elements, it's stated in the first section of the law. Number one is for someone to be punished under Batas Pambansa Bilang 22. It should be any person who makes, draws, or issues any check for account or for value. So when we say for account, it refers to pre-existing obligations, while for value, it means an obligation incurred simultaneously with the issuance of the check. Number two, he has knowledge at the time he issued the check that he does not have sufficient funds in or credit with the drawee bank for the payment of the check when presented for payment. So, although the drawer does not have sufficient funds, if he has sufficient credit with the bank to pay for the check, he does not violate the law. So, in this context, the word credit is used to mean an arrangement or understanding with the bank for the payment of such check as defined in Section 4 of BP Bilang 22. So, for instance, the drawer might have an overdraft line with the bank. So he might have an arrangement with the bank that the deposit in his savings account will be applied to pay for any check he issues in case the balance in his current account is insufficient. If the drawer made such arrangement and the bank dishonored the check because it overlooked the arrangement, the drawer incurs no liability. On the other hand, if despite such arrangement, the bank dishonored the check because at the time the drawer had assigned his savings account as collateral for a loan, the drawer violated the law. For, for his savings account actually was not available to pay the check. Okay, so for the third element, the drawee bank dishonors the check because of insufficiency of funds, or it would have been dishonored for the same reason had the issuer or the maker of the check not ordered for a stop payment for no valid reason. So it was the maker will still be punishable under BP Bilang 22. Now, you might realize or observe that these two laws doesn't have that much of a difference. So let's try to pinpoint their main difference. So for the revised penal code resulting to estafa, it does not penalize the dishonor of a check issued in payment of a debt contracted prior to such issuance. So, meaning, estafa or Article 315 of the Revised Penal Code is not applicable for pre-existing obligations, whereas BP Bilang 22 or 22 actually penalizes the dishonor of a worthless check given in payment of a pre-existing obligation. So, Revised Penal Code is just applicable for debts contracted simultaneously at the issuance of the check. So, also, for Article 315 of the Revised Penal Code, deceit should be the efficient cause of the defraudation and damage was made. Whereas, in BP Bilang 22, deceit and damage are not essential. So with this, crime committed under BP Bilang 22 is actually against public interest. So, while for Article 315 of the Revised Penal Code, it's crime against property. So, for Batas Pambansa Bilang 22, it is a crime against public interest because it does injury to the entire banking system. Actually, many have questioned its constitutionality because, according to them, it's been stated in the Constitution that no person shall be imprisoned for non-payment of debt, and that this law is somehow a veiled device to coerce a debtor to pay his debt under penal sanctions. But then again, it is not the non-payment of obligation which this law punishes, but the act of making and issuing a worthless check and putting them in circulation, which then creates deleterious effects on the public interest. So, this law, BP Bilang 22, it punishes or penalizes the mere issuance of a check without sufficient funds. Okay, so in addition, uh, Article 315 of the Revised Penal Code is actually mala in se, while BP Bilang 22 is mala prohibita. So, what's the difference between these two? So, violations for estafa, they're mala in se, meaning they're wrong in itself or by nature. Thus, good faith is a proper defense. So, good faith may be demonstrated perhaps by a debtor's offer to arrange a payment scheme with his creditor or making full payment of the entire amount of the dishonored checks. So, BP 22 is mala prohibita, meaning it's wrong because it is prohibited by law, but not wrong in and of itself. Therefore, good faith is not a defense in BP Bilang 22. So, our last distinguishing characteristic is according to their penalties. So, for Article 315 of the Revised Penal Code, it is punishable by penalties of imprisonment ranging from 2 months to 8 years depending on the amount of the fraud. Whereas in BP Bilang 22, it is punishable by penalties of imprisonment of not less than 30 days but not more than 1 year, or by a fine of not less than but not more than double the amount of the check, which fine shall not exceed 200,000 pesos, or both such fine and imprisonment at the discretion of the court. Okay, so those are the major difference of both laws. So, just a brief history of the law. BP Bilang 22 actually started off as being included in the Penal Code of Spain. So it penalizes the act of defrauding another through false pretenses in Article 335. So although there was no explicit mention that was made regarding checks, this Article 335, was deemed to cover the issuance of worthless or bogus checks in exchange for money. So in 1926, an amendment was made to specifically include the issuance of worthless checks. Now in 1932, the Revised Penal Code was enacted, and provisions penalizing such issuance was incorporated in Article 315, resulting to estafa. That's again paragraph 2D of Article 315. So it, however, such article deemed to exclude checks issued in payment of pre-existing obligations. So, from what I've mentioned earlier, the main difference between BP 22 and Article 315 resulting to estafa is that Article 315 of the Revised Penal Code does not include those obligations that are pre-existing. Now, what the law that covers pre-existing checks issued for pre-existing obligations is actually BP Bilang 22. Now, to remedy this, since, di ba, it was the Revised Penal Code that was approved first. It was approved in 1930. So, during the time that there was no BP 22, they used Article 315 of the Revised Penal Code. So, meaning, checks issued for pre-existing obligations were not penalized. So, we now need another law to penalize those checks that were issued for pre-existing obligations. So, to remedy this, the Congress introduced amendments to Article 315 That is through passing RA 4885. So it is actually an act to amend Article 315, Section 2D of the Revised Penal Code. So it was amended to include supposedly the checks issued for pre-existing obligations. But again, with the Supreme Court's decision in the consolidated cases of People versus Sabio, Tan Tao Liap versus Court of Appeals, and Lagua versus Kusi, it was resolved that the amendment of Article 315 through RA 4885 still did not make the issuance of checks with no funds estafa if the check was issued in payment of a pre-existing obligation. So again, despite the amendment, the checks issued for pre-existing obligations was still not covered in such law or in such amendment. So maybe uh, it was because the concept underlying the crime of estafa are false pretenses or deceit. And in those cases that I've mentioned, deceit was not established. So take note again, for BP Bilang 22, deceit is not an element. So this deceit is not necessary for a crime or for a case to be subjected to BP Bilang 22. So maybe because of the decisions on these cases, Solicitor General Estelito Mendoza was not able to sleep, so he was able to draft um, Cabinet Bill number 9. So he was the one who sponsored it, which bill later became Batas Pambansa Bilang 22. So that was the history of this law. So maybe you may ask, what are the specific offenses penalized under BP Bilang 22? Who could be the persons liable under this law? What constitutes evidence of knowledge of insufficient funds on the part of the drawer? What is the duty of the drawee bank? What defenses are available against BP Bilang 22? And if there are two laws that punishes the issuance of bouncing checks, we have the Revised Penal Code and the BP Bilang 22 as well. How can there be no double jeopardy? So I will answer all these questions during my report on Saturday. So thank you so much for listening to this recording, and I hope to see you guys on Saturday, and I hope to answer your questions by then. So thank you once again.